With the permission of the Lordship, may I start?
The state. The current case is one such scenario which seeks aid from the fundamental rights to protect its citizens. The issue at hand is that of breach of these rights through a flawed legislative enactment which transgresses these boundaries and breaks the balance between the fundamental rights and the legitimate state interest. Mr. Ian, who's a mere suspect of a crime...
Could you explain that point further? I didn't get that.
Yes, my lords. There's an investigation of a crime, the murder of Mr. Anand going on. In this current scenario, there is no imminent threat that the government can claim which is present to for the disruption of public order, and by that virtue, it is given that the IT Act was enacted to provide legal recognition for transactions carried out by means of electronic data interchange. Find that there is a need for this act. It will in no way satisfy the test of proportionality laid down in this test. As it is given that the IT Act was enacted to provide legal recognition for transactions carried out by means of electronic data interchange. Find that there is a need for this act. It will in no way satisfy the test of proportionality laid down in this test. As it is given that the IT Act was enacted to provide legal recognition for transactions carried out by means of electronic data interchange. Find that there is a need for this act. It will in no way satisfy the test of proportionality laid down in this test. It is given that the IT Act was enacted to provide legal recognition for transactions carried out by means of electronic data interchange. My lord, proportionality means that the nature of enforcement of the right to privacy being done here should not be disproportionate.
What exactly is
My lord, proportionality means that the nature of enforcement of the right to privacy.
what exactly is the doctrine of proportionality? What exactly is the doctrine of
it was stated that whenever a government enforces the right to privacy, they use restrictive measures intended for doing so. My lord, it's a foreign company, therefore.
So what?
Article 19 doesn't apply to foreign entities.
Why?
My lord, as per the article, it's only Indians who have the right under
Indians?
What is the term used?
Citizen. Citizen. My lord.
Company is not a citizen? Why?
My lord, it is not as per the article, it's only Indians who have the right under article.
What is the term used?
Citizen. My lord.
Company is not a citizen?
The fact that this, my lord, it is not as per the article, it's only Indians who have the right under article. Notwithstanding the covert nature, there is also no safeguards in terms of oversight of another branch of
Company is not a citizen?
The fact that who passes the orders to the executive, who reviews the orders to the executive, this gives overarching powers to the executive, which also might affect balance of powers between the branches of government. Oversight of another branch of government. The executive is also arbitrary and unreasonable. That is worded to the rule that they may set aside the order which they have reviewed is not in accordance with the provision might affect balance of powers. So, this is given that even the executive, the order is in contravention of the provision of the rule, the executive committee has the protection not to set aside at all. The word is may and not shall. The procedure established for partial review orders in Menaka Gandhi states that no one can judge the case in which they have a vested interest. It's also been breached here, as anybody above the rank of joint secretary is allowed to pass orders for decryption interest and
How did you, what was the observation in Maneka's case?
My lord, I'm referring to a particular observation. It stated that it's also no one can judge a case in which they have a vested interest. Joint secretary. My lord,
What is the
my lord,
you can't be attributing justice to the government.
No, my lord, I'm not attributing judge. My lord, anyone above the rank of joint secretary is allowed to pass orders for decryption, monitoring, or interception as per the act, my lord. And such people are also part of the review committee which reviews the very same orders, my lord. That is where they have the restriction. They are reviewing their own orders. Is allowed to pass the point for decryption.
Your concern will be addressed if we say that the two different authorities should do that. Will you be satisfied without, it doesn't violate? However, this can be easily rectified.
So this gives it further onus to have procedural safeguards which make the section waterproof, my lord. orthodox ideas. My lords, the issue with the current provision is investigation of any offence is not mentioned in 19.2, and thus the council contends that cannot be a ground for the government to go ahead and ask Mr. Ian to decrypt the data. Moving on to my third sub-issue, which is on the right to equality. When it comes to Article 14, the section does not follow the classification test and is manifestly arbitrary as discussed in Shaira Banu. Section 16 of the IT Act is more invasive than Section 5, subsection 2, as it's a wide range of information available on the internet when compared to telegraphic communications. Even when it's more invasive, there is a larger extent of invasion of right to privacy when compared to the Section 5, subsection 2 of the Telegraph Act, which the Council is now trying to explain. The impugned section, which is Section 16 of the Information Technology Act, does not have the issue of public safety or public emergency to be present to trigger the application, which was given in Section 5, subsection 2 of the Telegraph Act. The government would have to just...
See, one second. See, India has entered into various covenants and international treaties with a large number of foreign countries. Now, that would include treaties and covenants with regard to transfer of data, transfer of information, etc. So, when India, as a nation, requests for some information from a company in a foreign country, and that is not passed on, then will it not affect the friendly relationship? Incriminating. It should by itself be incriminating.
Yes,
some other data they may come across in the smartphone that won't be self-incriminating as far as the present scenario is concerned, present case is concerned.
My lords, it's not to cite a case. It is not only evidence that will be self-incriminatory, but even has a tendency to self-incriminate the accused, my lords. The investigating authorities do not have any idea what is present in the smartphone. They do not have any idea what is present in the ICT technologies of the car, and thus do not know whether it is self-incriminatory or not. It is only Mr. Rian who's in a position to gauge whether such evidence will be self-incriminatory or not, and thus he has the right under Article 23 to claim that this is against my right of self-incrimination, as the data which is given to the government might contain something which has a tendency to self-incriminate, my lords. That is the contention that the council is trying to raise. My lords, therefore it is clear that the impugned section, it is clear that the contention of the council is that the impugned provision violates Article 14 because it's manifestly arbitrary, Article 21 as it violates the right to privacy and it does not follow the process of due process, and Article 20 subclause 3, my lords. In the light of the above violations, the counsel of the petitioner pleads that Section 16 of the Information Technology Act is ultra-vires of the Constitution. With the permission of my lords, I would like to pass it on to my co-counsel.
Counsel, the self-incrimination protection is given only for the statement or to even with respect applies to the evidence also?
My lords, it was stated in Kathikalu Guard that the term witness in Article 20, Clause 3 is not only confined to oral testimony but also includes documents, my lords.
Don't you remember Nandri Sapadi's case later in 1978? What is the implication of Article 20, Clause 3? Is it prohibitive of any evidence, or is it prohibitive of voluntary testimony?
My lord, it doesn't prohibit voluntary testimony, my lord. It's only
prohibit.
Sorry, I mean, it doesn't cover the aspect of voluntary testimony. An aspect is allowed to voluntarily testify, but force.
Okay. All right.
My apologies, my lord. It was a pleasure arguing before this court.
If I'm audible, I may start.
Please, go ahead.
Greetings to the esteemed bench. This is Speaker 2, appearing on behalf of the petitioners in the present case. My lords, as my co-counsel has endeavoured to establish Section 69 as an unconstitutional act, in the next few minutes, I shall aim to prove that the governmental regulations on cryptography in the form of the rules notified on 13th of August, as my lords may refer to paragraph 11 of the proposition, are too restrictive in nature. During the course of my arguments, I shall endeavour to establish two things. Firstly, that the rules dated 13th August and thus the authority created under the rules are in excess of the power upon the respondents. And secondly, that the rules are in breach of constitutional mandates, namely Article 14, 19 and 21 of the Constitution of Indica. If it may pleases the Lords, I shall begin with my arguments.
Yes.
My Lords, for the sake of clarification, to clarify the functionings of the authority as mentioned under in paragraph 11, what the authority is asking for is that every company that is operating in Indica has to submit their cryptographic algorithms mandatorily and get them approved by the company. Now, cryptographic algorithms are basically the mathematical functions that are employed by the organizations to encode their data. That is to change the plain data into a codified encrypted form so that not everyone can know of them. And secondly, the company can demand access to the private keys of the individuals, that is to decrypt that very data whenever as they deem necessary. To begin with my arguments, my lords, this goes in this power of the authority is in excess of the powers conferred under Section IT Act itself. Because firstly, my lords, while Section 69 gives extensive powers of investigation, interception, decryption of data, the Section 69 at no manner confers any power upon the respondents to create a new authority for these very purposes as mentioned in the Act. Secondly, my lords, there are plethora of organizations already existing that are empowered to carry out these same functionings that are provided to the authority. For example, my lords, Section 70B of the Information Technology Act, it provides that the government may formulate mechanisms pardon my lords, may formulate mechanisms by means of which it may keep vigilant suspicious cyber activity that may take place. This is the emergency response team created under Section 70B. Further, the respondents under a notification have already authorized 10 agencies to carry out the functionings given under Section 69 of the Information Technology Act. Now, my lords, the petitioners contend here that when there are already pre-existing authorities carrying out these very same functionings, and secondly, Section 69 does not give power to
council. So your contention is that they have the delegated legislation is beyond the delegated power to them. Is that your contention? That the rules framed under that is beyond the powers vested under 69, is it?
Yes, my lord. Because my lord, under Section 69, the government has the power to authorize a pre-existing agency. They cannot create a new agency.
Whether the rules are beyond Section 69 or Section 69 itself is ultra-vires of the Constitution. Which is your stand?
My lords, my contention is that the rules are beyond Section 69, the powers that are conferred by Section 69.
Please.
Could you just read the part which says that it is required to be a pre-existing agency?
My lords, if I may read Section 69, it says that where the central government or state government or any of its officers specially authorized by central or state government, as the case may be, if satisfied that it is expedient to do so in the interest of sovereignty, integrity, defense, security, friendly relations with state, public order, prevention of incitement of any offence, it may, subject to the provisions of subsection 2, for reasons to be recorded in writing or by order, direct any agency of the appropriate government to intercept, monitor, decrypt, or cause to be intercept.
What does it
Now,
mean?
my lords, that they can ask any agency to intercept, monitor, and decrypt.
Is it necessary that it's a pre-existing agency?
My lords, what the government has done is firstly that they have created a new agency for the purposes that other agencies are already authorized to do. Secondly, my lords, Section 69 does not touch upon the issue that they may demand mandatorily demand cryptographic algorithms from everyone in the country, my lords.
Does it say so? It doesn't.
My lords, when
under specific circumstances, it is also spelled out in Section 69 under what circumstances this can be asked for.
my lords,
It doesn't give an all-pervasive power.
my lords, that is exactly the contention of petitioners, because as per Section 69, it gives 3 powers, that is to intercept data, to monitor data, and to decrypt data. Now, encryption algorithms are clearly simply mechanisms that are to encrypt the data. They are not the data in itself. Thus, Section 69 does not give power to the government to ask for those encryption mechanisms, my lords. And secondly, my lords, these encryption mechanisms, they are asked mandatorily, not under any specific circumstances.
Okay, supposing excessive power is given under the rules,
Yes,
then can you challenge the provision, the statutory provision in the Act based on that?
The statutory provision, as in Section 69, my lords.
As in Section 69, yes.
My lords, the petitioners have challenged Section 69 because it confers excessive powers upon the government, excessive powers of investigation, and secondly, the terms that are mentioned under 69, they are very vague and ambiguous, my lords.
Okay.
What is 3A? Could you read that?
Yes, my lord. Of Section 69, my lord.
Right.
The subscriber or intermediary or any person in charge of the computer resource shall, when called upon by any agency referred to in subsection 1, extend all facilities in technical assistance to provide access or secure access to computer resource.
Then how will you say that the powers are limited to B only?
B only.
Upon an agency is directed to provide access to the government agency. 3A says.
My lords, if you may repeat the question.
You just said that the power of the government agency is limited to intercept, monitor, or decrypt information.
Yes, my lords.
But 3A insists that it shall the authority shall be provided with access to or secure access to the computer when called upon by the government agency. Am I right?
Yes, my lords. Yes, my lords. My lords, when we talk about decryption of or interception of a data, then it is implicit that the authority may gain access to the computer in which the data is stored. However, my lords, this still would not lead us to access the cryptographic algorithms, my lords, because cryptographic algorithms are mainly just mathematical functions that are to decrypt the data.
Madam Counsel, are you speaking sense? Is it mere access to a computer, or is it access to information? What is intended by Section 69 of the IT Act?
My lords, the intention of Section 69 is the access to information, and this is, my lords, if I may permit me to speak.
Come on.
And this is the only reason why the petitioners are asking as to why do they demand the cryptographic algorithms, because algorithms in themselves, they do not contain any information whatsoever that may incriminate a person or may lead the government agency
so
to
what is your problem in sharing with that? It is like there is a room locked with the information or some material. The government want to know the access to get the information, right? That is a lock and key you have. We are just asking the lock and key. Our only purpose is not to use the lock and key for something else. Whenever we need information, we'll open and see that. That's it.
My lords, if we talk about the constitutional mandates that I have addressed further in my arguments, we see that the government needs some sort of reasoning as to why they demand something.
There are 5 reasons given under 69 itself. Security of the state.
My lords, this brings us back to the question as to if the encryption mechanism does not lead to security of the state, Then what is the reasoning behind asking the encryption mechanism, my lords?
Who
No,
decides
what
that?
is stored
I'm
inside?
Pardon, my lords?
Sir, please.
What is stored inside may have some impact on the sovereignty of India or the security of the state. So we need
Yes,
to have access. The government is intended to see that.
my lords, for the sake of clarification, when the government asks mandatorily for cryptographic algorithms, cryptographic algorithms in themselves, they cannot lead to data. Because, my lords, for the sake of the ease of the bench, I may present an example. If we talk about WhatsApp text messages, which are end-to-end encrypted, my lords, that means even WhatsApp cannot access those text messages. Now, this end-to-end encryption is basically a form of code. If the government gets access to this code, which even WhatsApp has access to, does not mean they get access to the data, my lords.
Are you sure about it? Because even with WhatsApp, the government of India has to share the encryption data so that they can get whatever information shared in the WhatsApp.
Yes, my lords, what the government has demanded of WhatsApp is that they introduce a backdoor policy in their system. That is, they remove this end-to-end encryption and then the government can access the data. However, as long as there is this presence of encryption, that they are seeking to protect, my lords. What the petitioners are trying to do is ask the government as to why do they need this surveillance mechanism that asks us to mandatorily share our algorithms with the government. Furthermore, my lords, these algorithms can only be employed by agencies when they are approved by the government, my lords. That is the contention of petitioners, my lords. If my lords are satisfied,
Yes.
I shall proceed with my arguments, my lords.
Yes.
Um, My lords, when there is a pre-existence of authorities which have the same functioning, then the onus falls upon the respondents to clarify as to what different purposes this authority serving and how it's not a burden on state exchequer. Moving on to my second prong of the argument, my lords, is that the rules are in contravention of constitutional mandates, namely 14, 19 and 21 of the Constitution. When we talk about Article 14, we see that the governmental action must not be arbitrary in nature. Now, this one of the tests for arbitrariness was given in Shaira Bano versus Union of India, which talks about manifest arbitrariness. An act should not be done capriciously, unreasonably, without an adequate determining principle, and disproportionately, so that it is not arbitrary. My lords, when we talk about the facts of the present case, this authority has given such wide powers of discretion in the hands of executive that it is subject to the whims and caprices of the executive. Because also, my lords, there is no overseeing authority and hence it is capricious in nature. Secondly, my lords, when we talk about reasonableness and adequate determining principle, then there is no reasoning provided as to why they need to approve the cryptographic algorithms, firstly, my lords. And secondly, when we talk about Section 16 of the Information Technology Act, it's, if I may read for the convenience of the bench.
Yes.
Section 16 says that the government may formulate, prescribe the security procedures and practices, but those are to be but while prescribing such procedures and practices, the government shall have regard to the commercial circumstances, nature of transactions, and other related factors as it may deem appropriate. My lords, the government has not provided any valid reasoning, because whatever terminology is given under section 69 is very much vague and ambiguous and can be interpreted as per the wish of the employees of the executive, my lords. Thirdly, my lords, when we talk about proportionality...
Could you just explain the concept of ambiguity here?
Yes, my lords. My lords, for an example, when we talk about ambiguity, investigation of any offence, for example, even in this case. Now, investigation of any offence gives wide ambit of powers in the hands of authorities. However, this offence has not been defined as what limit of offence are we talking about. Offence can range from anything from a theft to something as grave as a terrorist attack. This is the wide ambiguity and wide scope of powers that have been given in the hands of respondents, my lords.
What is the ambiguity there?
My lords, the ambiguity comes from the, if we see it from the lens of proportionality, we cannot inflict the same graveness of investigation or the same punishment for an offence of theft as we can do it for the in case of a terrorist.
No, are we not, sir? Without interrupting, are we not dealing with the power of the investigating agency? We are not speaking about the imposition of penalty as such. We are speaking about the process of investigation.
My lords, if I may continue.
Oh, sure.
My lords, even when we talk about investigation, then a balance has to be struck between the privacy or other rights of an individual and then the investigation offence. Even if we talk about CRPC, the provisions provide that the investigating authority has to get a warrant signed by a judicial officer. All these are safeguards just to seek that there are no extreme powers of investigation vested in the hands of the police officers, my lords.
Yes,
if I may proceed further, my lords.
Yes.
When we talk about the test of proportionality, which was laid down in the case of Puttaswamy Aadhar judgment, we see that it gives 4 measures. Firstly, a measure restricting right must have a legitimate goal. Secondly, it must be suitable means of there must be suitable means of furthering this goal. There must not be any less restrictive but equally alternate measures. And fourthly, that it must not have a disproportionate impact on the right holder. Now, my lords, when we talk about less restrictive measure, we see that there are plethora of less restrictive measures that the police could have obtained or chosen instead of straight away going for the ICT facilities, if we talk about the present case, my lords.
Can you give some examples?
Yes, my lords. If my lords may refer to... Yes, if my lords may refer to paragraph 13 of the Moot proposition, we see that there were vehicles that passed through the highway and the police identified the owners of the same vehicles, my lords. Now, the petitioner would seek 3 things, my lords. Firstly, the police, it's not clearly given in the Moot proposition that the police investigated other car agencies as well. Secondly, my lords, the police could have asked the whereabouts of Mr. Ian and then investigated if he was actually there in those places. For example, Mr. Ian was passing through a highway. It means he was going somewhere. The police did not even bother going to that place, investigating whether he reached, whether he did not reach. They straight away went for the ICT facilities of his car because that was the most convenient option for them, my lord.
No, but then this encrypted key, if it is made available, that will give more perfect data, is it not? They don't have to go after all this because the application contains, or rather, once it is open, then they know from where the car is started, where all it has stopped, where all it has, for what time it has stopped. All these data will be available.
Yes, my lords.
Yes. Now, why do you say lords, that there is a conflict between the less invasive or measures and the measure under Section 69? They operate in separate fields, is it not?
Yes, my lords. My lords, when we talk, if we talk about the present case, the government, the police investigating authorities will get accurate data if they straight away go for the ICT facilities. But my lords, what we need to see here is that if the police, instead of opting for other methods of investigation, other equally effective methods of investigation, goes for these ICT facilities, it straight away infringes upon the right of privacy of the petitioners. Firstly, because, my lords, if we look at...
Counsel, you are making this argument with respect to proportionality of the legislation.
My lords, if you talk about the present case, because my lord asked me regarding the present case whether the police authority should go after the ICT facilities. However, my argument, which was in regards to proportionality, was with regards to the authority, as in the authority, with whatever it is imposing, has a disproportionate impact upon the right holders.
That
Right
you
holders
cannot
being
only rely upon Ian's case. You have to convince us saying that it is not proportional to the end relief what they wanted. You can't take one
apologies.
isolated case and convince us that.
Apologies, my lord. I sought to answer the question asked previously. However, my lords, when we talk about the disproportionate impact on right holders, the disproportionate impact is something which I have discussed as a violation of Article 19 upon the right holders, my lord, as well as Article 21, my lords.
And then you can answer lordship question, because you are trying to confuse that with the proportionality test. Here, what lordship is asking is whether when there is an authenticated scientific evidence is available, any other less reliable information should be believed, should the investigation be believed.
Exactly.
My lords, if may grant me an extension of 2 minutes, I will answer the question and quickly sum up my arguments.
Carry on.
Much obliged, my lords. My lords, if we talk about the PUCL case, it was said that telephonic interception should be done in the gravest of grave circumstances, only in instances of public emergency. And this term public emergency was also very much clearly defined in concrete terms, that it could not include situations such as financial emergency. Now, my lords, if we apply this principle to the present case, we see that they are not asking for this in the gravest of grave circumstances. They are asking it blatantly under every situation that they can ask for. Further, my lords, when we talk about the disproportionate impact on the rights holder, we seek to address it in two folds, which is Article 19 and Article 21. When we talk about Article 19, my lords, which is the right to free speech and expression, what the government is doing here is creating a chilling effect on the citizenry, because they will have this constant apprehension that their everyday conversations or their business transactions can always be asked by the government and can be manipulated and used against them. As this is also seen in the case of Pegasus, PUCL, and if you talk about internationally, then of course the NSA surveillance case of 2013, my lords. Moving on to the third aspect, my lords.
Are you aware of the case? The Supreme Court, we have already decided, this court has decided that you cannot force a person to give a DNA against his own will, even though it is scientific evidence.
Yes, my lords.
My lords,
I was referring to the Pegasus, PUCL, and NSA surveillance cases, my lords. If my lords may clarify the relation between the two, I may.
If you are saying that even in the absence of scientific evidence, like you cannot be forced to share with your data, in the encrypted data in your car. It is similar to the DNA, like asking a person to undergo a DNA test, though it is a scientific evidence.
Yes, my lords. The petitioners are only contending that when there are less restrictive measures available, the investigating authorities, to strike a balance between their investigation and the rights of the individual, should opt for the less restrictive measures.
No, please.
My lords, when we talk about privacy, I'd mentioned this one precedent, which is the District Registrar and Collector versus State of Canada Bank. Their Supreme Court of India affirmed that the right to privacy of an individual, it extends to his or her information that is held by a third party. That is to say that even if a person's data is with third party companies, they still expect it to remain safe from state scrutiny, my lords. In the judgment of Puttaswamy, the Supreme Court highlighted the importance of judicial review before the invasion of privacy. That is, the government needs to obtain prior approval from judicial officers before they curb this right to privacy. My lords, in today's day and age, encrypted information extends from everyday text messages to something as grave as health records, business transactions. When the government asks for these algorithms and keys with no restrictions whatsoever, it gives leeway for misuse of their data, not only just to the state, but to other anti-social agencies as well, my lords. Thus, my lords, in the light of these submissions made above, the Council humbly presents before this esteemed court that the cryptographic algorithms as notified, that the governmental regulations on cryptographic algorithms as notified are indeed too restrictive in nature. If my lords permit, I'd move on to my prayers.
Yes.
It is humbly prayed before this honorable court to declare Section 69 of the Information Technology Act as ultra-vires to the Constitution of Indica. Secondly, to declare the rules formulated with respect to cryptographic tools as notified on 13th August, ultra-vires as Constitution of Indica, and pass any other further orders in favor of petitioners as this court may deem fit in the ends of equity, justice, and good conscience. It was a privilege arguing before the esteemed bench, my lords.
Thank you, speakers. Representing the petitioners, with the permission of the lordships, I would like to invite speakers representing the respondents to commence with their arguments.
Yes.
Permission to address the bench collectively as your lordships.
Yes.
Much obliged, your lordships. Your lordships, this is Counsel 1 on behalf of the respondents in the case of CG Car Company versus the Union of Indica. I, Counsel 1, will be dealing with issue 1, whereas my co-counsel will be dealing with issue 2. Now, I would like to present 3 material facts in our case. That is, Mr. Anand and Mr. Ian used to eat at the same cafe. Mr. Ian, not many vehicles had passed on the day of the death of Mr. Anand, and Ian's car was the only car that took the longer time. And the third is that the police notified CG Car Company to hand over the private key. Now, with the permission of the bench, I would like to proceed with my arguments.
Yes.
Much obliged, your lordships. Now, the issue 1 deals with constitutional validity of Section 69 of the IT Act. The respondents would like to present this argument in 5 main prongs. The first is that it falls well within the reasonable restrictions laid down. The second, vehicular information does not qualify as personal information. The third is that the petitioners cannot invoke the infringement of right against self-incrimination. The fourth, that it complies with safeguards under Section 69. And the fifth is the admissibility of illegally obtained evidence is valid. Moving to my first prong of argument, that it falls well within the reasonable restriction. The Puttaswamy judgment laid down 3 main tests to qualify as a reasonable restriction. The first is the test of legality, second, the test of necessity, and the third, the test of proportionality. Now, under the test of necessity, there has to be an existence of the law, whereas the IT Act is the existing law, which has been passed by the Parliament according to Article 248 of the Constitution. The second is the test of necessity. Now, for the test of necessity, there must exist a legitimate state aim. Now, in the current case, the investigation of a criminal offense is the legitimate state aim, and acquiring the private key is in furtherance of this legitimate state aim. We would also like to submit the case of Facebook versus Union of India, where the court highlighted that...
Madam, just one clarification required. How do you invoke Article 248 for investigative powers?
Your Lordship, no.
Deals with Article 248 deals with the legislative powers, and investigation is an action by the executive. How do you bring in Article 248 in the investigative process?
No, Your Lordship, we are not bringing it in the investigative process, but in the existence of a law, that is the IT Act, which has been passed through the residuary powers of the legislation. If I may proceed with my...
Is IT law under the residuary powers?
Yes, Your Lordship, because the information technology would fall under residuary according to 97 entry list of...
Not not under the telecommunication, the entry in the telecommunication.
No, Your Lordship.
Okay, all right.
Much obliged, Your Lordship.
Counsel, this argument is not needed. You are wasting your time, because that is not their case. They never say that you don't have competency to do that. Then you can say that I have powers under residuary. Even neither the court nor the petitioner stated that.
Yes, Your Lordship. I'll move on to the next test, that is the test of necessity. The legitimate state aim is the investigation of the offense. We would like to submit the case of Facebook versus Union of India, where the court held that decryption, if made available easily, might violate the fundamental right to privacy, but under special circumstances, it may be allowed. The court verbatim laid down that The sovereignty of the state and the dignity and reputation of an individual are required to be protected for the purposes of detection, prevention, and investigation of criminal activities. It may be necessary to obtain such information, which is in the current case as well, Your Lordship. Now, the third test is the test of proportionality. For the test of proportionality, there are three main necessities. It must serve a legitimate goal, a suitable means of furthering this goal, and there shall not be any less restrictive alternative. The legitimate goal in the current case is the investigation. Acquiring the private key is in furtherance of the investigation, and there exists no such information technology laws currently that could be an alternative to Section 69. We would like to submit the case of Anuradha Basin, which dealt with Section 5, Subsection 2 of the Telegraph Act. And the court held that in the cases of interception, it can be allowed as long as there is a lawful interception. That is the legitimate state aim as well. If the court is satisfied, I would like to move on to my next contention.
No, just one query. Just one
Yes, sir.
query. See, from the materials that are available, Ian is only a suspect. He hasn't even acquired the character of an accused. Can you, at this stage, insist for the encrypted keys? You suspect he had provided an answer. The data that is provided would show that he had provided an answer to the questions put to him by the investigating agency. But then the investigating agency is not satisfied, fully not satisfied. But by that, he does not acquire the status of an accused for you to compel him to provide this information. He's just a suspect. What do you say about that?
Your Lordship, that falls under the right against self-incrimination, whereas the argument is that the petitioners cannot invoke the right against self-incrimination, which is my third prong. But if the court may allow me to finish my second prong and move on to the third.
No, my question is, I'll complete my question. You don't you need something else, something more concrete for you, for him to acquire the status of an accused and for you to compel him to provide the encrypted keys? Can you from the initial stage the argument that other more or less invasive measures are available in other statutes would apply, would it not? Or you should be having more concrete evidence with you?
No, Your Lordship, the facts of the case are clear that Mr. Ian and Anand used to eat at the same eatery, and there also were not many vehicles on the highway that night. And the only vehicle that took longer than usual was Mr. Ian's vehicle, which is why the contention is being made.
Yes. Does it justify or satisfy the requirement of need that you pointed out with the three parameters? You say
yes,
that would satisfy the requirement of need.
Yes, Your Lordship.
Yes.
Because
okay. Yes.
My next argument is that vehicular information does not classify as personal information. Now, according to the Puttaswamy judgment, it clearly laid down that location details can be acquired for, as shown in the compendium, can be acquired for criminal investigations, and that the petitioners cannot ask for a right to privacy. Now, if the court may permit, I would like to present the DPDP Act. Although it's not enforced in the current case, it enshrines the principles of Puttaswamy judgment, which is basically a codified version of the Puttaswamy judgment. May I present it?
Yes.
Okay. It defines personal data as any data about an individual who is identifiable by it. But in the current case, the vehicular information, such as charging events, enabling, disabling various systems, do not classify as personal information. Therefore, there is no infringement of right to privacy. The European guidelines, which extensively dealt with vehicular information, also categorizes vehicular information into three types, one of which is offense related data. Now, it is in consonance with Article 10 of General Data Protection Regulations, which states that data can be acquired in criminal convictions and offenses under the control of an official authority. So in the current case, as the investigation officers would like this data, it should be submitted. This is in consonance with...
Can you answer this? See, we understand very well that when the process of investigation you can do as a state. However, we are not very comfortable with the rule which says that the authority on control and regulation of cryptography, herein referred as authority, and the prior approval of the authority was necessary for using any cryptography. How it is? How do you can control all the cryptographic algorithms before even they are being used? Why do you want to have them prior being put into use? Is it not a unnecessary measure there beyond the purpose for which the 69 is being drafted?
No, Your Lordship, because the asymmetric cryptographic tool states that there has to be a private key and the public key, whereas the petitioners have not submitted the public key, and the public key can only be accessed when the
No, my question
directions.
is very simple. There may be a private key with them, but as and when there is a need arises, you can approach them.
Your
But why
Lordship,
do you want to have a blanket even before there is any offense or anything going to happen? Before that, it's like a censorship without reason. What is the reason for it?
No, Your Lordship, because it clearly states that the competent authority has to give a direction. Only then the key can be accessed.
No. Read para 11
Of the
of the
proper.
proposition. Yeah,
Yes, Your Lordship.
third line you read.
The rules mandated that cryptographic algorithms are proposed to be used for any purpose by anyone to be submitted to the authority, and the prior approval of the authority was necessary for using the same.
Why? Only if it is used for unlawful purposes, you can do that. If you are saying that it is a normal traffic data, it is a vehicular data which doesn't have any significance, why you have to want to control over it?
Your Lordship, only when there arises a situation where there violation of national security, public order, or an investigation of a crime, it would be necessary for the government to decrypt this data, and that's why there's a prior approval needed from the competent authority as well.
So we will strike down saying that only prior approval not needed, as and when there is a need, the government can approach it. Is it?
Your Lordship, currently it's not in the section 69. So,
Please proceed.
yes, Your Lordship. So the European guidelines, as stated, is in consonance with Section 69 of the IT Act and also Section 17(1)(c) of the DPTP Act, which states that Part 3 of the Act, which talks about notice requirement, consent requirement, purpose limitation, and erasure of data, can be foregone in the cases of criminal investigations. Now, we would like to submit the case of Johnson Control Technology, where the court declared that the vehicular information system, which was required as evidence in that case, did not classify as personal data and was submitted to the court. Now, if the court is satisfied, may I move on to my third argument?
Yes.
The third argument is that the petitioners cannot invoke an infringement to right against self-incrimination. As previously stated, they hadn't submitted the public key, and for invoking the right against self-incrimination, there has to qualify three necessities, according to the Nandini Satpathy case. The first is the formal accusation, which is okay. The first is the formal accusation. The second is that they are required to give evidence against themselves, and the third is that there shall be no compulsion. The first one, formal accusation, there has been no formal accusation in written document against Mr. Ian in the current case. And the second is that they're required to give evidence against themselves, whereas in my previous prong, it does not qualify as personal information. That's where it will not qualify as evidence against themselves. And the third is that no compulsion. No compulsion has been created by the police in the current case either. And also, we'd like to point out that if the private key is not submitted, it will indulge in alteration of the data stored within, which is in violation of Section 65B of the Evidence Act, that states that no evidence shall be submitted that is altered. If the court is satisfied, may I move on to my fourth contention?
So the council is saying that Ian is not compelled, but
Exactly.
only the car companies are compelled. Is it your argument?
No, Your Lordship. Neither of them are compelled here.
Okay.
Yes.
So what will be the fallout if it is not provided? Any consequence?
Sorry, Your Lordship.
Supposing both Ian and the car company refuses to provide, what will be the consequence?
Your
As far as
Lordship,
the
according
investigation is
to
concerned, yes. Carry on.
according to Section 69 of the Act, 7 years of imprisonment plus fine.
Then why do you say there's no compulsion?
Uh, there's no compulsion created according to the right against self-incrimination, where they have to give evidence against themselves.
Okay, carry on. Yes.
The fourth contention is that it complied with the safeguards for Section 69. For this, we would like to submit the case of PUCL versus the Union of India, which laid out 3 safeguards. The first is establishing necessity, which we have previously proved in the test of necessity. The second is purpose limitation, and the third is storage limitation. For this, we'd like to show that there's an information technology rules of 2009, which is in furtherance of the Section 69 of the IT Act, that clearly states that the evidence, the data collected will be destroyed after 6 months, therefore complying to the purpose limitation and storage limitation as procedural safeguards. If I may move on to my last contention, Your Lordship.
Yes.
The last contention is that the admissibility of illegally obtained evidence is valid. Now, in the case of State of Maharashtra versus Natwarlal Damodar Soni, it was held, assuming that the search was illegal, it did not affect the validity of the seizure and its admissibility in evidence. At the most, the court may be inclined to examine it carefully, but the evidence relating to the seizure is not declared invalid. According to this case, the hacking, even if the hacking was performed, the evidence would not be inadmissible in court. In the Bharti Tamang case, it rejected the argument.
One second. What will be the evidentiary value of such information gathered in such manner when it is tested against Article 23? Even then, it will be admissible evidence according to you.
Yes, Your Lordship.
Okay.
In the case of Bharti Tamang, where there was interception rules as well, the case rejects the argument that the intercepted materials violate constitutional rights. The court holds that it's premature to exclude such evidence, which is exactly correlated to our current case, where the intercepted or decrypted materials do not violate any constitutional rights. Now, I would like to conclude my arguments by stating that there is no violation of right to privacy, and there is no violation of right against self-incrimination. If there's any questions, I would like to address them. Okay. My co-counsel will take over, and any remaining time, please add on to this.
Yes.
Permission to collectively address the benches, Your Honor.
Yes.
Much obliged, Your Honor. Your Honor, I am counsel number 2, appearing on behalf of the respondents in this present case of CG Car Company and others versus the Union of India. I would be dealing with issue number 2, and this issue is the one that deals with the question as to whether or not the governmental control over these cryptographic techniques are too restrictive in its nature or not. Your Honor, the respondents humbly submit before this honorable court that the governmental control imposed over these cryptographic techniques are not too restrictive in its nature and they are justified. And we will be proving why in a series of arguments. The counsel seeks permission to proceed with the arguments.
Yes.
Much obliged, Your Honors. Your Honor, the first prong of our argument would be that the mandatory sharing requirement of the cryptographic algorithm with the authority on control and regulation of cryptography is valid because it is in line with the parent legislation, that is the Information Technology Act of 2000. Your Honor, if you refer to paragraph 11 of the Moot proposition, we see that it states that on the 13th of August 22, the central government notifies certain rules and regulations with regards to the usage of cryptographic tools. Now, these rules stipulated that anybody using a cryptographic algorithm for any purpose would have to submit the same to the authority along with the duplicate key. Additionally, it also stated that that for anybody to use a cryptographic algorithm, prior approval from the authority is necessary for the same. Now, Your Honor, it may be contended that the above stated restrictions are too restrictive in its nature. However, it is in line with a number of provisions of the parent legislation, that is the IT Act of 2000. If you look into section 84A of the IT Act, it states that the government is empowered to prescribe modes and methods for encryption. And then if you look into section 16 of the IT Act, It states that the government is empowered to prescribe security practices and security procedures for the purposes of securing electronic documents and electronic signatures.
Council, these sections which you are saying are only the ways in which a secured environment be created, because before that there was no secured protocol available. Our concern is that why do you need a censorship before they're using any encryption? Why it has to be pre-approved by you?
Your Honor,
What is necessity for that?
Your Honor, this is merely a preemptive measure taken by law investigative agencies to stay ahead of the law and order situation.
Can you do
Preemptive
that?
against everyone, and the presumption everyone is a criminal.
Your Honor, there is no presumption that everyone is a criminal, but as stated in this above case itself, Mr. Ian and the CG car company both did not comply with the requirements of Section 69 of the IT Act, and this did not enable them to conduct their investigations, which is the power to conduct an investigation is certainly something in the interest of the general public. And when they are not allowed to do so, it would be against the interest of the general public. Therefore, it's
in that case, no, it is after the incident happened. If they refuse to cooperate, the 16 itself gives you power. You take corresponding action. Force them to give it.
Your Honor, that may give powers to criminalize them under Section 69 of the IT Act. However, if a graver offense had been committed and such information was not able to be accessed by the encryption of said data, in that case, again, it would be a situation where the law investigative agency are not able to exercise their powers to the full extent.
No, the rule is it not far in excess of what is contemplated under Section 69? Now, Section 69 says only on being satisfied and that it is necessary or expedient to do so, and under 4 circumstances that are made out, that is interest in sovereignty of the nation, defense of India, friendly relations, etc. Then alone you can ask for this data. Now, the rule gives an all-pervasive power. It does not say, as Brother Senthil pointed out, see, even prior to, you have to give it in advance, encrypted data. Why do you insist on that? And how can you insist on that? That is in conflict with the parent statute, does it not?
Your Honor, Section 69 talks about issuing of a direction to decrypt certain information. However, the rules that have been just mentioned don't talk about issuing a direction of a decryption, but rather talk about the security practices and procedures that have to be established for the usage of an encryption system. And Section 16 of the IT Act that does empower.
If all these data is to be provided in advance, then what is the purpose of Section 69? See, the government is in control of all the encrypted data in advance. They don't have to ask anyone. They can straight away use it, is it not? Then why Section 69 and the condition that only on satisfaction of certain conditions you can require this data? That becomes redundant. That becomes obsolete, is it not?
Your Honor, even then, Section 69 of the IT Act does so only in particular grounds, and the above rules mentioned, they talk about how it's merely a preemptive measure to make sure that the encryption methods that have been used are in line with the provisions of the law, so that there's not a possibility of the encryption standard be circumventing the law because it is being too advanced or because it is not in line with the standards as set by the government of India.
Okay.
Your Honor, to continue, Section 87, Clause 2, Clause A also empowers the government to make rules under Section 16 of the IT Act. Thus, we contend that, citing the case of Indian Oil Corporation versus Municipal Corporation of Jalandhar, that any delegated legislation that is in line with its parent legislation is certainly deemed to be valid. Now, Your Honor, I'll move on to the second prong of my argument, which is about the adequacy of procedural safeguards. Now, Your Honor, in the case of PUCL versus Union of India, as well as in the case of Menaka Gandhi versus Union of India, both of these cases held that for any legislation that is giving power to the government, certain rules and regulations must be created under it to ensure a fair and reasonable exercise of power. Now, Your Honor, in the case of PUCL versus Union of India in particular, which dealt with the Section 5, Clause 2 of the Telegraph Act, it stated that there was a lack of adequacy, there was an inadequacy of procedural safeguards because there were rules absent, rules under it were absent. Now, Your Honor, that is not the case in Section 69 of the IT Act. In 2009, the central government notified the Information Technology Procedure and Safeguards for Interception, Monitoring and Decryption Rules of 2009. And these clearly provide an adequacy of procedural safeguards that ensure that there isn't an unreasonable exercise of power. In fact, In the case of POCL itself, they laid down the number of guidelines that were necessary to ensure that they were an adequacy of procedural safeguards. And on comparing them to the rules given in the 2009 rules, we see that the 2009 rules provide for all of those and go further and beyond that. And just a reference, Your Honor, Rule 3 of the 2009 rules is very similar to the first guideline given in the PUCL case. And then if you look into Rule 8 given in the 2009 rules, it's again very much similar to Guideline 3 given in the PUCL case. Similarly, Rule 11 given in the under the rules is similar to Guideline 5. And Rule 16 again is in consonance with Guideline 6. And then apart from that, 22 is in consonance with Guideline 9. 23 is in consonance with Guideline 8. And apart from that, the rule number 24, 25, and 6 all are additional safeguards that are not even been provided for in the PUCL case. Therefore, there clearly is an adequacy of procedural safeguards as it goes even above and beyond the safeguards given in the PUCL case. With that, Your Honor, I'd move on to the third prong of my argument, which is that it is not a violation of Article 19(1)(g). Your Honor, in the above case, the petition was filed by CG Car Company as well as other car manufacturers, stating that the restrictions imposed by the government would likely substantially affect their businesses in Indica. However, Your Honor, that in itself would not amount to an infringement of Article 19(1)(g). In the case of Maganbhai Ishwarbhai Patel versus the Union of India, they held that for there to be a writ of mandamus issued against an infringement of Article 19(1)(g), there needs to be a real or an actual infringement of a right and not an apprehension or an infringement of a right. Your Honor, in the above case, the factual matrix is clear that there was no actual effect on the businesses of the car companies, but they only felt that their businesses would likely to be affected, indicating an apprehension of infringement but not an actual infringement. Thus, it is not a violation of Article 19(1)(g). Additionally, in the case of Krishnan Kakanath versus the government of Kerala, they held that any restriction resulting imposed on Article 19(1)(g).
Counsel, that fact situations are there where they ask for a mandamus against the government. Here it is not so. Here they are asking us to strike down the law itself. So they may not show that something has happened. They can only show that it is ultra-vires the provisions of the Constitution. That is sufficient.
Your Honor, even in this case, the contention, Your Honor, even in this case, it is a writ of mandamus that has been issued, that has been requested for under Article 32 of the Constitution, which is why we believe that it would be applicable in the above case. May I proceed, Your Honor?
Is it a writ of mandamus when you challenge it?
Yes, Your Honor. Because there's been a challenge under Article 21 of the Constitution of India as well.
What circumstances are writ of mandamus? Is a writ of mandamus issued?
Your Honor, it is issued when it is issued to a government agency, telling them to perform in a certain way when they have overstepped their powers.
Will it apply then? Here.
Your Honor, that's the writ.
When the challenges against a statute on the ground that it is unconstitutional.
Your Honor, Your Honor, since this case talks about an infringement of rights, the writ would be with regards to implementing measures that ensure that these rights aren't infringed. Therefore, it again would qualify as a writ of mandamus.
Okay.
Yes. Your Honor, continuing with my arguments, to cite the case of Krishnan Kakanath versus the government of Kerala, they said that any restriction imposed under Article 19 must have a direct impact on the right to practice business, but not an incidental or an ancillary effect. Your Honor, in the above case, there was no direct restriction on their right to practice business within the car industry. The only effect might have been an incidental or an ancillary one, which, as stated by the case above, would not amount to an infringement under Article 19(1)(g). Additionally, in the case of Nazaria Motor Services was the state of Andhra Pradesh, they held that any restriction resulting in the diminution of profits of a particular entity would not amount to an infringement of Article 19(1)(g). In the above case as well, Your Honor, the only damage that may happen to the petitioners in the above case is that businesses are likely to be substantially affected and their sales and their profits would be hit. That, again, does not amount to an infringement of Article 19(1)(g). Your Honor, move on to my next prong of my argument, which is that the restrictions so imposed are reasonable restrictions under Article 19. Your Honor, Article 19, Clause 6 provides for provides for imposing restrictions in the interest of the general public. That is one of the grounds that have been mentioned, which are considered to be reasonable as a restriction. Now, Your Honor, let's talk. The terms in the interest of the general public has been interpreted in a very wide manner in the cases of Ramji Lal Modi versus the state of Uttar
Mr.
Pradesh.
Counsel, 19 clause
1G, Your Honor. The restriction, the interests of the general public have been mentioned in Article 19. Your Honor, while this case talks about public order,
which 19 clause
6,
restricting which right?
Article 19(1)(a). But Your Honor, if we go on
in which semester the council is there?
Your Honor, 4th semester.
You have studied constitution law?
Yes, Your Honor. Your Honor, I just like to go to Virendra versus State of Punjab.
All right. Come on. I don't waste time.
Virendra versus State of Punjab. Your Honor, in the case of Virendra versus State of Punjab, they also held that a restriction imposed in the interest of the general public. Now, the term in the interest of the general public has been one that has been specifically used in Article 19, Clause 6 of the Constitution of India, which relates to the rights given under 19(1)(g). And Virendra relied on the judgment given in Ramji Lal Modi, which is why we have submitted the two above citations. May I proceed, Your Honor?
For sure.
Yes.
Yes, Your Honor. So the interpretation of the terms in the interest of general public has been interpreted in a very wide manner, which means that the protection that it so offers by imposing such a restriction can be against any particular evil against the interest of the general public. Now, Your Honor, the powers under Section 69 of the IT Act lays down the grounds under which these powers can be exercised. The grounds mentioned are sovereignty or integrity of India, defense of India, security of state, friendly relations, public order, preventing incitement of an offense, or investigation of any offense. Your Honor, all the grounds.
The last one you mentioned, investigation of any offense. That
yes,
is too wide. That is too wide a term, is it not? Now compare it to the earlier provisions in interest of sovereignty of India, defense of India, etc. When compared to that, you apply the principle of adjustum generis. This stands out, does it not? For investigation of any offense.
Your Honor, when we say investigation of any offense, it is the right given to law investigative agencies to investigate any offense. If we're not giving them this power to do so, it would clearly be against the interests of the general public, as it would lead to a situation of chaos and a lack of order. And therefore, we're suggesting that
they have powers under the CRPC.
Your Honor,
yes. They have sufficient powers under the CRPC. So far, they have been functioning under the CRPC. Why all of a sudden give them some power and you don't define what any offense is?
Your Honor, why this distinguishes from the CRPC is that it also talks about the decryption of a particular information, which is not explicitly given within the CRPC.
Okay.
Your Honor, another case I'd like to cite is the previously cited case of Krishnan Kakanath versus the government of Kerala. In this, they held that the reasonableness of a restriction imposed must be determined from the standpoint of not the person whose rights have been allegedly infringed, but from the standpoints of the general public. Your Honor, since, as I've stated, the restrictions so imposed are in the interest of the general public, and the restriction imposed, no matter how harshly it affects the petitioners, would still be amount to reasonable restrictions. Your Honor, may I move on to my next prong of argument? Much obliged, Your Honor. The next prong of my argument is that the restrictions imposed are in consonance with the Code of Criminal Procedure of 1973. Your Honor, Section 91 of the CRPC states that a police officer or a court is empowered to issue an order or a summons for the production of any document or anything to any person which they deem desirable in the interest of in the interest of an investigation, inquiry, trial, or any other proceeding. Now, Your Honor, we see that Section 91 of the CRPC and Section 69 of the IT Act provide very analogous powers to the public authorities. Now, Your Honor, I'll cite a number of cases that upheld the validity of Section 91 of the CRPC. The case of Om Prakash Sharma versus CBI, it held that the only requirement for exercise of powers under Section 91 of the CRPC would be to show that the documents that have been summoned or ordered to be summoned are necessary or desirable in the eyes of the investigative agent or the one issuing the summons. Additionally, in the case of CBI versus Vijay Sai Reddy, they held that for the exercise of power under 91 of the CRPC by a police officer, there is no requirement of a prior court order, which not only validates section 91 of the CRPC, but also states that judicial overview is not necessary in such circumstances. Additionally, in the case of Arjun Pandit Rao versus Kailash Gorantyal, they held that for the summoning of any documents under 91 of the CRPC, it would also mean to include electronic documents, which plays again a high relevance when you compare it to section 69 of the IT Act. Thus,
Counsel, that is what my brother said. Like, when already you are given so much power and the courts have held it very valid, why it is such a draconian legislation, which is far more than the reach what it wants to reach?
Your Honor, with the growing digital age and the technological advancements, it is imperative that we enact a legislation that also grows and is able to counter the such technical advancements and take a control on the law and order situation, which is why the section 69 of the Act and other restrictions imposed are necessary.
Carry on. Yes.
Your Honor, my next prong of argument would be that it is in consonance with the DPDP Act of 2023. Now, we submit that it has not been enforced yet, and therefore we are submitting it as an as a persuasive source, along with the K.S. Puttaswamy judgment for the reasons stated by my co-counsel as an authoritative source. Now, if you refer to section 36 of the DPDP Act, it states that the government is empowered to call for any information from any intermediary or a data fiduciary. Additionally, section 35 of the DPDP Act states that no suit can be initiated against the government for any action taken by them in good faith. Additionally, 17(1)(c) of the DPDP Act states that
the earlier restriction which you mentioned,
yes,
does it take away this court's power under Article 32?
No, Your Honor. This does not take away the powers of the Supreme Court or, in fact, even of the High Court under 226 or of the Supreme Court under 32.
Okay. Yes.
Your Honor, 17(1)(c), which talks about how personal information can be processed if it is in the interest of prevention of an offense or an investigation of an offense. And additionally, 17(2)(a) talks about how an agency or an instrumentality can process personal information for the grounds that have been provided for in section 69 of the IT Act. Apart from this, I'd also place reliance on the non-personal data governance framework. The MP Gopalakrishnan Committee Expert of Committee report, which brought out the non-personal data governance framework, stated that the government does have a right to process non-personal information for sovereign purposes. And the meaning of sovereign purposes has clearly been mentioned as data required for crime mapping, devising anticipation and preventive measures, and for investigation and law enforcement. Thus, it is also certainly in consonance with the non-personal data governance framework, and thus we submit that it is not too restrictive in its nature. If now the court seeks no further clarification, we would like to move on to the prayer. Much obliged, Your Honor. In light of the issues raised, arguments advanced, and the authorities cited, the counsels for the respondents humbly pray that this honorable court dismiss the above writ petition. It has been an honor arguing before this honorable court, Your Honor.
Okay.
Thank you, Speaker. Now, with the permission of the Lordships, I would like to invite the petitioners for the rebuttals.
My lords, with your permission, I would like to start rebutting. Firstly, I would like to ask my learned friend here. One aspect which they hadn't covered is how investigation of any offense is covered under Article 19(2), and because the very act of surveillance infringes upon the right to freedom of speech and expression, as it has a chilling effect. So I would request my learned counsel to clarify how it comes under Article 19(2), and when it comes to the aspect of proportionality, my learned friend had discussed how Rule 8 also makes the investigating officers look for alternative measures. The proportionality that the council here is trying to propose is not the proportionality of attaining the information, but the proportionality of obtaining the information itself is necessary, is what the council is trying to contend with respect to privacy. Why haven't they looked into other measures, such as looking at other witnesses, looking at the other cars which passed by? Why have they directly gone to the ICT framework of the car is the question that the council is trying to raise. Thirdly, they, as my councillor rightly contended, that the data in the vehicle only will not amount to self-incrimination as it is not part of personal knowledge. But they did not justify the fact that for accessing such data, they had to go to the mobile or the ICT facilities connected to the car, which contains other personal information. You can't differentiate both. You can't get one without the other. The council seeks clarification how this is not in violation of right to self-incrimination. Uh, Lastly, for the procedure and safeguards for interception, as my learner friend rightly contended, a lot of the rules are in consonance with the PUC framework. There's one particular rule which the council would like to point out, which is Rule 23, Clause 2. Why is the government destroying the orders for directions given is something that is unjustified. I would like to pass it on to my other co-counsel for her rebuttal.
If my lords may permit, I'd humbly seek to start with the rebuttals. My lords, firstly, my learned friend stated that the petitioners have not submitted the public key. My lords, to clarify, public key is already in the public domain. The petitioners, it is in the control of every person because public key is what gives access to the data, to encryption of the data, my lords. What the petitioners are arguing against is the submission of private key, which even the IT Act provides is only under the control of the individual, as is given under section 14 and 15, that in order to establish a secure digital signature, the private key should be in control of this digital signatory. Secondly, my lord, it was stated that it is asking for algorithms is a preemptive measures, as they do not ask for it mandatorily. However, my lords, what we see in paragraph 11, it is clearly stated that you have to submit the algorithms mandatorily, and to use them you have to get them approved from the authority. This brings me to my third point. My learned friend contended that cryptographic...
Could I ask one clarification?
Yes, my lord.
In the case of the films and other media, you find that there is pre-censorship.
Yes, my lord.
But in the case of print media, there is no pre-censorship as such. Don't you find that the same classification can be taken with reference to the IT devices and the other materials through which the articles can be information can be passed? So what is wrong with pre-censorship in the case of IT devices? Because it is likely to cause more harm, just like the visual media and like the print media.
My lords, it is upon the prerogative of the government to establish preemptive measures. However, my lords, what we are contending is that you cannot put a blanket restriction and you cannot put this blanket requirement upon every person without any reason behind it whatsoever, my lords.
Okay.
If I may proceed further, my lords. My learned friend contended that the government should ensure that the encryption standards do not circumvent law by being too advanced. My lords, now we contend here that should the government prevent the securing of the data of the individuals if the companies are employing standard encryption, strengthened encryption policies? Is that not a good thing? Lastly, my lords, what we see is that section 81 says that IT Act is a self-contained act. Hence, it cannot be put, if my lords may grant me an extension of 15 seconds.
Yes.
Much obliged, my lords. Section 81 of the Information Technology Act says that Information Technology Act is a self-contained act, and hence it cannot be reviewed through the lens of other act as per the DPDP Act or the CRPC. We need to look at it as an independent legislation through the provisions of the Constitution. Are the only things that it can be tested upon, my lords. The council rests their submissions. Much obliged, my lordships.
Thank you, Speaker. Now, with the permission of the Lordships, I would like to welcome the respondents for this rebuttal.
Your Lordships, one of the contentions made by the petitioners is there's no proportionality and other methods of investigation should have been chosen, but for the reasons of quick investigation, speedy judgment, and they choose this method so that they can easily reach a conclusion and which can reduce the cases pending in the court as well. Now, another contention made by them is they said that it does not violate the right to self-incrimination because some parts of the data do not classify as personal data, which is exactly what we are contending, your lordships, that it does not classify as personal data, which is why it cannot be submitted, that they have a infringement of right against self-incrimination. And the fourth is that no public key shall be submitted, but the proposition clearly states that there's an asymmetric cryptographic tool used to store this data, whereas in the IT Act, it defines asymmetric cryptographic tool as a existence of a public key and a private key. That means that the public key had to be submitted to the competent authority, whereas it had not been submitted by the petitioner. And the last one is the algorithm. The petitioners emphasized on algorithm multiple times, whereas acquiring the private key would lead to the data, which is not personal information and hence should be submitted to the investigating officer. Now my co-counsel will take over.
Permission to proceed with the rebuttals, Your Honors.
Yes.
Much obliged, Your Honors. Your Honor, one of the contentions brought about by the opposing counsels was with regards to how the investigation of any offence is a reasonable restriction. Your Honor, as stated by the previous cases of Virendra versus State of Punjab, the investigation of any offence is in the interest of the general public when applied the wide interpretation of the term in the interest of general public as held by the same case. Another contention brought by the opposing counsel was with regards to Rule 23 and how that is not an adequate procedural safeguard. However, Rule 23 is again very analogous to Guideline 8 given in the case of PUCL versus Union of India, which is why again we contend that the court did uphold as a procedural safeguard in that case, and thus it does amount to a procedural safeguard over here as well. The third point I'd like to bring about was the contention made about encryption standards. Now, Your Honor, we're not suggesting that the government imposes restrictions on encryption standards that do not allow securitization, security of data. Your Honor, in fact, to give a few examples, in 2001, the RBI report on internet banking prescribed encryption standard of 128-bit. And in 2000, the SEBI guidelines on internet-based trading and services prescribed an encryption standard of 64 or 128, which even at that time was an increasingly strong encryption standard. The aim behind enforcing such encryption standards is not to prevent not to prevent that data should not be secure, but for it to be in line with the provisions of the Information Technology Act. And thus, with that, Your Honor, we submit our rebuttals.
We've come to an end of the final rounds of Dr. A.D. Markose Memorial Technology Law Moot Competition 2024. Thank you, everyone. Thank you, Your Lordships. Now, with the permissions of Your Lordship, I would like to request all the participants and the court officers to leave the meet at once.